The following is the structure of the competition. There will be three stages: petition meetings, respondent meetings, rebuttals, and further parties. Each stage should have a maximum of 45 minutes, of which 25 is the maximum time to be allotted to each stage. This includes the rebuttal and further parties. The judges may seek clarification and these questions related to the argument. However, the time will not be paused during such times. So we can run after reading permission of the judges.
You can start. Okay.
The council seeks permission to address residents collectively as much as possible. For involvement in the argument, is the visual submission, and I should be dealing with the first and the fourth issue that is whether the provision of the DPP grants permission to process data without consent under section 6 and the other provisions which we have to violate the policy, and the issue of the last code section 17 was violated by the 14 in this constitution. And also the two will be reading the government second. If the lordships are aware of absolutely the council will be specific. Lordships with regards to the whether the Act 22 of 2023 allows the processing of open data without consent of the provider and allow permission right. Also, before proceeding to the council like to elucidate the Data Protection Act that is in place, and we would like to elucidate section 6 and the which is related to the section which allows the processing of data without obtaining consent to data. The lordships will please refer to section 6 of the DPP Act, specifically section 6 clause 6. This is clearly an enabling provision that allows the section 6 clause
6, yeah.
This is merely an enabling provision which allows for processing of data without obtaining consent under the provisions of this Act. This particular provision is the rule, and section 17 and section 7 is the exceptions to this particular rule. Section 7 provides the data without obtaining the consent. It provides for some exceptions that have been granted to many parties, including state and existing parties. The lordships of the council has control is not questioning the different various benefits that have been granted under section 7 of the DPP Act. For example, the provision with regards to emergency Medicare, etc. The council is challenging merely the provision in section 7D, which grants a blanket exemption or blanket power to the states and municipalities to use data or process data without obtaining consent. Furthermore, since this particular proceeding is under the Article 32 of the Constitution and the issues have been framed by the Honorable Bench, the council would refrain from moving into the merits of the case to discuss the validity of whether the provisions of the DPP Act is in violation of the Constitution or not. The council merely places arguments based on the constitutional law that is being framed by the Honorable Court and like to establish that there is indeed a right violation of right privacy with regards to section 6 and other provisions.
Lordships, in furtherance of the first issue, the council would like to make a three-pronged arguments. The first limb of my submission would be with regards to the violation of the right to privacy under Article 21 of the Constitution. The second limb of my submission would be with regards to inadequate procedural safeguard, which therefore violates Article 21 of the Constitution. And therefore, and furthermore, the third limb of my submission would be with regards to blanket exemption from general duties of a data fiduciary to states, its instrumentalities, and notify data fiduciaries, your lordships. If your lordships are convinced with the split of the first issue, the council pleads to proceed with the first limb of my submission. Much obliged. Lordships, with regards to the first limb of submission, that is whether this particular provision violates the right to privacy under Article 21 of the Constitution, the council will first like to cite the case of Menaka Gandhi versus Union of India, where it has been established that any violation of Article 21 of the Constitution must adhere to a procedure that is fair, just, and reasonable, your lordships. Lordships, the council accepts the fact that Section 7 and Section 17 is a procedure established by law as given under Article 21 of the Constitution, whereby even though the right to privacy is not an absolute right, it's subject to procedure established by law. But the same procedure established by law is subject to the rulings of the Honorable Supreme Court in the case of Menaka Gandhi versus Union of India, whereby the test of fair, just, and reasonableness needs to be established, Your Lordships. Furthermore, the Council would like to submit the compendium for Your Lordships' benefit.
Yeah, it's here.
Much. The Council would like to apologize. We have only 2 copies of the compendium. Your Lordship, the Council please takes Your Lordship's attention to page number 7 of the compendium,
Yes, sir. Yeah.
whereby the judgment of the Honorable Supreme Court in the case of K.S. Puttaswamy versus Union of India has been produced.
Yeah.
Specifically, paragraph number 310 of the judgment, page number 7 of the compendium. Lordship, it is pertinent to mention that the Honorable Supreme Court in the case of K.S. Puttaswamy versus Union of India has given a three-pronged test to determine whether an act is an invasion of privacy or right to privacy of an individual. And the same test was further elucidated by the Honorable Supreme Court in the case of Anuradha Bashim versus Union of India, which is given under page number 15 of the compendium, Lordship. The Council please takes Your Lordship's attention to page number 15.
15, yeah.
Your Lordships, the highlighted portions is the 4-pronged test that was laid by the Honorable Supreme Court in that particular case, whereby the first limb of the test is whether the action must be sanctioned by law. The second is the proposed action must be necessary in a democratic society for a legitimate aim. The third is the extent of such interference must be proportionate to the need for such interference. And there must be procedural guarantees against abuse of such interference. The Council would like to place reliance on the last 2 prong of tests, which is given by the Honorable Supreme Court in the case of Anuradha Bashim versus Union of India, whereby the Council pleads before this Honorable Court that there is no procedural safeguards in place to restrict the state and its instrumentalities from using the personal data of an individual beyond what is necessary, which is given under the provisions of the DPDP Act. And the Council will also like to establish that there is no proportionality between the objects sought to be achieved by the statute as well as the intended, as well as Section 7 of the DPDP Act. To understand the intent of the legislation and the purpose in which the DPDP Act was enacted, the Council would like to take Your Lordship's attention to the preamble of the DPDP Act, Your Lordships. Reading verbatim the preamble of the DPDP Act, an act to provide for the processing of digital personal data in a manner that recognizes both the individual's right to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith and incidental thereto, Your Lordships.
Council, this is the long title.
Your Lordships?
You're referring to the long title of the act, right?
Indeed, Your Lordships. Council is trying to establish the objective of this particular statute by placing the reference to the same, Your Lordships. Your Lordship, there is twin objective with regards to implementation of the DPDP Act. One is to protect the personal data of an individual, and the other is to process such personal data for lawful purpose, Your Lordship. Your Lordship, it is the humble submission of the petitioner that the provisions of the DPDP Act provides a blanket exemption to state and its instrumentalities to use the personal data of an individual of a data principle and does not have any repercussions for the same, Your Lordships. For this, the Council would like to take Your Lordship's attention to Section 17 of the DPDP Act, Your Lordships. Your Lordships are with me in Section 17.
Yeah.
The Council would read the second clause of Section 17, whereby it states, the provisions of this Act shall not apply in respect of processing of personal data. By such instrumentality of state and as central government may notify in the interest of sovereignty, integrity of India, security of the state, friendly relation with the foreign state, maintenance of public order, or preventing incitement to any cognizable offense relating to any of these and processing by the central government of any personal data that such instrumentality may furnish to Your Lordships. Lordship, the Council would now take Your Lordship's attention to the 4th subsection of this particular section, which the provisions of Section 7 of Section 8 shall not be applicable, Your Lordships. Section 7, subsection 7 of Section 8 deals with the right to be forgotten or the right to erasure of data. Lordship, this particular provision provides a blanket exemption to state or its instrumentalities from this affecting the right to be forgotten of a data principle, Your Lordship. This is one limb of submission that the council is trying to make before this honorable court. Lordship, now the council would like to take a Lordship's attention to section 7 of the DPDP Act, Lordship, whereby the legitimate use has been provided. Lordship, specifically, section 7, subsection D deals with the use by state or its instrumentalities. Reading verbatim what is being given. For the state and any of its instrumentalities to provide or issue to the data principal such subsidy, benefit, service, certificate, license, permit, or as may be prescribed, she has previously consented to processing of her personal data by the state or any of its instrumentalities for any subsidy, benefit, service, certificate, license, or permit, Your Lordships. Now, reading the next provision, which is for the performance by the state or any of its instrumentality of any function under any law for the time being enforced in India or in the interest of sovereignty and integrity of India or security of the state, Your Lordship. Lordship, the council is trying to establish before this honorable court that this particular provision is very expansive in nature. The meaning of the interest of sovereignty and integrity of India and security of the state cannot be interpreted in such a manner that it affects the right privacy of the data principles. The respondent will never be able to establish that providing immunity to Medicine Co. is in the interest of protecting the sovereignty, integrity, and the national interest of the state, Your Lordships. The council, in furtherance of the submission, would also like to state that since right to privacy is an inalienable right that was given by the Honorable Supreme Court in the case of K.S. Puttaswamy versus Union of India, and and the Honorable Supreme Court has also mentioned about a tailoring effect, whereby if any provision restricts the right to privacy, the restriction must be very specific, Your Lordship. In the instant case, the restriction is not very specific; it's very ambit. The ambit of this restriction is very wide, and therefore affects the right of privacy of the individual, Your Lordships. Your Lordships,
What specific evidence do you have to show that the data collected by Medicine Co. was processed without explicit consent and that this led to a tangible harm?
Indeed, Your Lordships. Your Lordships, for this, the council, though it's going into the facts of the case, the council would like to answer Your Lordship's question. The council would like to go on to the Annexure 2, Your Lordships. Your Lordships, it's the Annexure 2, the first part of the document talks about the payment data. It states we collect data necessary to process your payment if you make purchases such as your payment instrument number, and the security code associated with your payment instruction. Your Lordship, it is pertinent to mention that this particular contract does not have a third-party agreement, Your Lordship, whereby there is no clause in this particular agreement which grants permission to the data fiduciary in the instant case to send these data to a third-party organization to obtain for the purpose of processing of such data. Even on a wide interpretation.
Data permission page.
Your Lordships?
There is a data permission page, and in appendix number 2. There is a data permission page.
Indeed, Lordship. This page is with regards to the data principal and data fiduciary. That is the citizen at large or the public at large and Medico, Your Lordships. This particular document does not talk about sharing of the information to Safety GPT, which is a third-party private organization. So that's the humble submission that the council is trying to make. Even interpreting the clause 8 of this particular data permission of appendix 2, which talks about for the purpose of business, it cannot be this particular sharing of such sensitive data such as bank account details can never be considered as a business purpose of Medico in the instant case, Your Lordships. Further referring to section 6 of the DPDP Act, whereby it specifically states that the consent must be specific, unambiguous, Your Lordships. If the counsel for the respondent ought to say that there is an implied consent, it goes against the very principle that was issued under section 6 of the DPDP Act, which states that the consent must be specific and unambiguous.
Second question from my side is, how do you challenge the classification of storing and using bank account details for recurring payment as a legitimate purpose under section 7? Can you explain that?
Indeed, Your Lordships. Your Lordships, though this particular issue would be dealt in detail by my second counsel, I would give an overview of how we would be defending this particular issue, Your Lordships. Your Lordships, the European Union's GDPR has given a 3-pronged test to determine the legitimate interest tests from which.
Is that binding on this court?
Your Lordships, though it is not binding on this particular on the Honorable Supreme Court of India, it is pertinent to mention that the DPDP Act has taken reference to the GDPR, and the Honorable Supreme Court in case Puttaswamy versus Union of India has also recognized the GDPR's guidelines that was given by the European Union. And as a persuasive value, the Council is placing reliance on the test of legitimate interest, because for the simple reason that the DPDP Act does not provide a test, rather just gives the instances where the data could be used for legitimate use, Your Lordships. Your Lordship, it gives a three-pronged test with regards to necessity, usage, and proportionality, which will be explained in detail by my co-counsel, Your Lordships. If that answers Your Lordship's question, the Council requests if any other questions that.
Now, the point is whether the law with the Apex Court declares is the law for India. Any precedent which the Apex Court lays down, the Apex Court is not bound, but the High Courts and courts below High Court, they are bound by it. How the decisions or principles of law of the European Union or else a foreign court, they are binding upon the courts in India.
Your Lordships,
You can just get some inspiration,
indeed.
but they are not authoritative precedents.
Indeed,
They are only
much-
persuasive.
Much obliged, Lord. The Council is placing reliance on the GDPR's legitimate interest test just to have a persuasive value,
Yeah.
for the simple reason that there is no test similar to that in India
That's
to
correct.
determine the legitimate use, Your
Yeah,
Lordships. That's the
I got confused with you reading 7B and 7C together.
indeed, Your Lordships.
Do you want to read it together or is it two separate clauses?
Your Lordships, though there are two separate clauses, Your Lordships, it gives wide extensive power to the state and its instrumentalities to use or process the personal data of the data principle. The reason why the Council cited Section 7B and Section 7C is to simply state that the term instrumentality of the state has been liberally interpreted by the Honorable Supreme Court, Your Lordships. Lordships, as simple as a BSNL or the network providing industry could be given the status of an instrumentality of the state if this Honorable Court decides so, based on the principle that was laid down by the Honorable Supreme Court in the case of International Airport Authority versus Shetty, whereby a deep and pervasive control of the state is necessary to establish instrumentality of the state, Your Lordships. The reason why the Council cited this is because since a liberal interpretation has been given to the term instrumentality of the state, even an entity such as the BSNL could be granted immunity under Section 7, which goes against the very purpose of this particular legislation. That is the sole intention why the Council placed reliance on the same. Your Lordships are satisfied with this submission. The Council pleads to proceed to the next one. Lordships, the second limb of my submission with regards to the same is that there are inadequate safeguards within the DPDP Act, and therefore it violates Article 21 of the Constitution, Lordships. Lordships, it is necessary that in the case of Menaka Gandhi versus Union of India, wherein it was stated that procedure which deals with the modalities of regulating, restricting, or even rejecting a fundamental right falling under Article 21 must be fair, carefully designed to effectuate, not to subvert the substantive right itself, Your Lordships. And therefore, since there is a right given in the instant case as a procedure established by law under Section 7 and Section 17, whereby the right of privacy of an individual has been taken away, this particular procedure must have certain restriction in place to and safeguards in place to uphold the right of privacy of an individual, Lordships. It must not be such a general exemption or a blanket exemption that is granted to the state or its instrumentalities, which gives the possibility of the state to act as a surveillance state and to use this particular data in perpetuity without informing the data principle in any instance, Your Lordships. This gives a possibility of abuse and which can be corrected by the legislation, and the Council is humbly here before this Honorable Court requesting for the same, Your Lordships. If Your Lordships are satisfied with this limb of submission, the Council humbly pleased to proceed with the next issue is with regards to whether 17 clause 5 of the DPDP Act is in violation of Article 14 of the Constitution.
Okay.
Lordship, before proceeding to the issue, the Council would again like to read 17 clause 5 for Your Lordship's benefit. Lordships, reading verbatim 17 clause 5. The central government may, before expiry of 5 years from the date of commencement of this Act, by notification declare that any provision of this Act shall not apply to such data fiduciary or classes of data fiduciary for such period as may be specified in this notification, Lordships. Lordships, again, the Council here is challenging the entirety of Section 17 clause 5 and not with regards to specific instance of medicine co in the instant case, Lordship. 17 clause 5 provides a blanket exemption again to the central government to provide an exemption to any data fiduciary. It does not provide just an exemption to a state actor or a non-state actor. It provides an exemption to any data fiduciary. It can be a state entity, a non-state entity, or even a private individual for that matter. And since for the reason proper guidelines again has not been placed before this honorable court, or the same cannot be taken as a reasonable classification under Article 14 of the Constitution, Lordships. Lordships, further to establish the reasonable classification or violation of Article 14 of the Constitution, the twin test of that was given by the Honorable Supreme Court in Ramakrishna Dalmia versus Justice Tendulkar needs to be followed, whereby there must be an intelligible difference and a rational nexus sought with regards to the objects sought to be achieved by the statute, Lordships. In the instant case, if the object sought to be achieved by the state is to protect the interest or to protect the privacy of an individual, this particular section directly violates this particular nexus, Your Lordships, for the simple reason that the scope in which the central government, which is an executive authority, to act has been very wide and ample, so that it gives scope for violation, or it does not give proper procedure or restricting provision with regards to the same, Your Lordships.
Isn't such exemption necessary for public purpose?
Your Lordships, the council accepts that certain exception can be given for public purpose. For example, taking analogical reference to the Essential Commodities Act, whereby there is a specific instance where central government by notification can give exemption for a certain type of essential commodities, Your Lordships. But then it is a conditional legislation. Lordship, in the instant case, it's an excessive legislation and therefore violative of Article 14 of the Constitution. Lordship, in support of this, the council would like to cite the case of In Re Delhi Laws Act case, whereby it was held by the Supreme Court that a legislation which is delegated should not delegate the law-making power or the policy-making power to the executive authority. Rather, it must be a conditional legislation. In the instant case, the law-making power or the power to exempt this particular application of this particular act for the period of 5 years has been given to the central government, which is an executive authority, goes directly in against the doctrine of separation of power, which is a basic structure of the Constitution, Lordships. And therefore, placing reliance on the same, the council humbly pleads before this honorable court to establish that there is no reasonable classification to establish that such powers can be given to central government in instant case. Lordships, placing reference to the merits of the case also, the council will be able to establish that there is a violation of Article 14 of the Constitution. The Lordship, it is an established fact that Medicine Co. is an entity which has commercial interest in to its name, Your Lordship. Even though it performs certain public welfare activities, such as providing medicine at a subsidized rate, the commercial nature of the entity cannot be taken away from the entity, Your Lordship. The council, citing the case of SP Gupta versus Union of India, the Honorable Court has said that the differential treatment ought to be made when a public entity is doing something in a commercial sense, Your Lordships. In the working nature of Medicine Co., there cannot be connect Medicine Co. to any of the other exempted industries or entities which is given under Annexure 1 of the competition proposition, Your Lordships. If Your Lordships have any questions with regards to the same, the council would like to answer.
So your argument is that there are no guidelines.
There is no proper safeguards and restricting provision to restrict the abuse of power of the state or its instrumentalities, Your Lordships. As for the simple reason that even though it's not binding on this particular honorable court, GDPR has in its 8 entities from affecting the right of privacy of an individual. Your Lordship, Indiana being a welfare state, Your Lordship, must be concerned about protecting the request. Another 30 seconds to sum up the issue. And therefore, as submitted earlier, since for the reason there is as the proportionality test is not been fulfilled in the instant case with regards to Section 6 and the allied provision, which is Section 7 and 17 of the DPDP Act. Section 6 and its allied provision is violative of right to privacy, and Section 17 Clause 5 does not have any reasonable classification and therefore violative of Article 14 of the Constitution, Lordships. It was indeed an honor to present before this court. Thank you, Lordships.
Next speaker. Yeah. So you will touch point number 2 and 3. Okay. Speaker 2.
Greetings to the esteemed bench. This is Counsel 2 appearing on behalf of the petitioners herein to address issues 3 and issue 2 in that particular order, Your Lordships. Your Lordships, the Council will be submitting the third issue in a threefold argument. The first fold of argument pertains to whether the breach of duty as a data fiduciary under Section 8, subsection 4 is present or not, and whether Medicine Co's actions are arbitrary and disproportionate. And lastly, Your Lordships, whether this can be construed to be an instrumentality of the state or not, Your Lordships. Relying on Section 8, subsection 4, the Council humbly submits that Medicine Company qualifies as a data fiduciary under the Impugned Act of 2023. Under Section 8, subsection 4, it mandates that data fiduciaries report breaches promptly. But in the instant case, the failure to disclose the breach within a reasonable time frame reflects gross negligence and non-compliance with these statutory duties. For the same purpose, Your Lordships, the Council would like to draw inspiration from the General Data Protection Regulation under Article 33, Clause 1, Your Lordships, which states that under 72 hours, a specific breach has to be reported within the set timeline. In the Instant Act, there is no such provision which stipulates that within a specific time period, a data breach has to be reported, which also construes the fact that there is a wide unfettered power that has been conferred on the company to report a particular breach, Your Lordships. And further, the Council would also like to cite the principle of informed consent, which was not followed in the instant case. For the same, Your Lordships, the Council would like to rely on the test of purpose limitation test, which was followed in the Article 5, Clause 1 of the GDPR, which states specificity, explicitness, and legitimacy as the cornerstones of as a test which has to be satisfied. Your Lordships, in this instant case, taking Your Lordship's attention to the second appendix, which pertains to the privacy policy. Your Lordships, in that under the payment data clause, there is no specificity with respect to the time frame under which the data will be processed, and the fact that the payment data will be stored in this instant case. The permission which was given under the provisions of the terms of the particular appendix only pertain to the collection of data, and not whether the secret codes or the security codes as well as the passwords and other banking details will be stored. And further, Your Lordships, since there is no explicit permission which has to be sought under Section 6 of the Impugned Act, this also fails that particular test, and also the fact that there is no legitimate purpose, since the Council will be getting at the point of whether there is an element of good faith or not in this particular case. The Council would like to submit by saying that this does not satisfy the test of whether there is a legitimate purpose, and the test as such remains unsatisfied.
Council, how are you defining good faith here?
Your Lordships, since there is no proper provision for good faith in the particular Impugned Act, the Council would like to draw the definition of Section 3, subsection 22 of the General Clauses Act, which states that when an act is done honestly, even though it may be negligent, it may be considered to be good faith. But in this instant case, there is no, although there is negligence on part of the data fiduciaries, there is also an intention or a lack of procedural safeguards which have been followed by the respondents in this instant case. For the same, Your Lordships, the Council would like to first of all differentiate that the immunity under Section 35 does not apply to the respondents in the instant case, for the mere fact that the respondents, that is Medicine Company, is not an instrumentality of the state. This is in furtherance or in subject of the test which has been laid down in the case of Ajay Hasya, and also the case of, Your Lordships, just a moment, Your Lordships. Ajay Hasya and the case of Pradeep Kumar Bishwas, Your Lordships, where the financial and functional and the administrative control of the particular entity must lie with the state. In this instant case, there is no indication as to the financial control, whether it lies with the state or not, and there is no degree of administrative control which has been exercised by the state over this particular entity. And the fact that, Your Lordships, at this juncture, the Council would like to quote that the respondents in their memorials have enshrined the concept of the doctrine of sovereign immunity. Lordships, it is with utmost respect that the Council submits that sovereign immunity applies only to sovereign functions performed by the entity. And since considering the fact that pharmaceutical business is not open only to the government, it is a function which is performed by entities apart from the government. And following that particular submission, the Council would like to place reliance that it does not fall under the immunity of doctrine of sovereign function. And further, Lordships, as a result of the same,
medicine companies' actions are deemed to be arbitrary and disproportionate, Your Lordships. For the same, the council would like to say that since there is a failure to report the particular breach, and also, Your Lordships, the council would also like to take Your Lordship's attention to page number 3 of the fact sheet, Your Lordships. If Your Lordships are with me, in the second paragraph, it states that the AI system was capable of not only taking the data which it had been granted the permission to receive, but also any data which was entered by the customers was listed and automatically stored by the AI software. In this instant case, it is apparent from the fact sheet that consent was not given for that the consent was taken for purposes which have been more than what has been stated in the privacy policy, which in turn factually also violates the purpose limitation test which was held in Article 5, Clause 1 of the GDPR, Your Lordships. And in line of the same argument, the council also establishes that in the case of Ajay Hasya, it was unequivocally held that arbitrariness is the very antithesis of Article 14. Since there is an unreasonable classification which has been laid down in this case between a private data fiduciary and a government data fiduciary, it is violative of Article 14. Also considering the fact that if the council may take a lordship's attention to Appendix 1 of the fact sheet, there is an unreasonable classification, or rather a classification which is not based on any past test or any reasonable classification which has been made with respect to entities that can gain exemptions under 75 or Section 35. There is no reasonable classification, or there is no guideline which was followed to classify the companies which are listed in Appendix 1 and the companies which are not listed in Appendix 1. In light of the same, the council submits that Article 14 in this instant case as to the classification and as well as the immunity under Article Section 35 of the Impugned Act stands violated.
But there are mentioned in the data permission page,
Indeed.
the purposes for which the information is collected to facilitate account creation and login process, to send marketing and promotional communications, fulfill and manage your orders. There are 8 purposes that have been mentioned clearly.
Indeed.
So, will you still argue that there is no reasonable care been taken here?
Indeed, Your Lordship, because the instant concern is with respect to the payment details which have been stored and not collected. The instant privacy policy page only talks about collection of data and not the storage of data. Storage of data beyond the limited period is violative and is antithesis of the data limitation, or rather the data minimization. Your Lordship?
What is the source of the law you're quoting?
Pardon, Your Lordship?
What law you're quoting that it is violative of?
Your Lordship, the council is not aware of the instant section in this instant case, but it is the principle of data minimization that the council is relying on, which is enshrined in the DPDP Act. Published. If Your Lordships are satisfied, the council would like to move with the second issue, Your Lordships, which pertains to whether the processing of bank account details constitute a legitimate purpose under Section 7 and the allied provisions or not. Your Lordships, it is with a humble submission that the council contends that the legitimate purpose test, as such enshrined in Article 5, Clause 1 of the GDPR, does not stand satisfied because of the fact that the sensitive financial data has been transferred to an unnecessary or an unspecific third party, where no such consent which is free, informed, or rather which is in consideration of all factors which have been enshrined in the privacy policy page has not been given in this instant case, which is a blatant breach of the transparency obligations. In light of the same, the council submits that Section 8 of the Act mandates that the data fiduciaries disclose the purpose of data collection and processing explicitly to the data subjects. So Medicine Co's failure in this instant case to notify the subscribers of the intended sharing of bank details constitutes a breach of the particular provision, Your Lordships. It is also to bring to Your Lordships' attention that under Section 8, subsection 6 of the Impugned Act, there is no notice that has been provided to the Data Protection Board, or rather to the data principals, which is an obligation of the data fiduciary which has to be followed. This only goes on to state that more than the fact that there is negligence in their actions, it goes on to state their intention of not notifying the breach to the concerned parties, which only further proliferates the data breach for the purpose which has not been specified in the instant agreement, Your Lordships. And further, Your Lordships, no clause in the instant agreement pertains to whether bank details can be stored or not, Your Lordships. Upon a perusal of all of the 8 clauses, the agreement contains no provision which authorizes that such data can be transferred to a third-party act in this instant case.
Is there an opting out option present?
Your Lordships, after the consent has been given, the facts are silent as to whether there is an opting out policy or not, but the consent which has been given is not used for the purposes specified in the particular privacy policy.
But if there is an opt out option,
indeed,
in terms of and conditions, can that be seen as an implicit consent mechanism?
Lordships, the fact that there is, the facts are silent as to whether there is an opt-out provision, the council cannot concede to the fact that whether that amounts to implied consent or not, Your Lordships. Obliged.
Here, in this case, the data is not transferred by the company.
Your Lordship?
It's a case of hacking, you know,
Uh,
or is it a case of transfer of data by the company to the website of some other company?
Your Lordships, the data in this instant case has been a third-party software
Yes.
under the name of Safety GPT has been employed to handle and the process that particular data, Your Lordships. So in the instant case, the consent was not provided to such third party being involved in this particular contract, whereas the privacy policy only pertains between the data principal
Okay.
and the data fiduciary, that is Medicine Co in this instant case.
That's correct.
Obliged. Lordships, further in the press release, if the council may take your Lordship's attention. Excuse me for a moment, Lordships. Your Lordships, it was conceded in the first paragraph. Apologies, Your Lordships. The council may take your attention to page number 4 of the fact sheet. Your Lordships.
Yeah.
4 and the associated page of 5, page number 5, Your Lordships. Lordships, in this instant case, the press release is claimed that Medicine Co operates as a government company under the control of central government and is subsequently protected against any legal action for actions taken in good faith. Lordships, this does not hold good in law because of the fact that under Section 35, only the instrumentalities or central government in and of itself can avail the remedy, whereas this company, as propounded in the test of Ajay Hasya and Pradeep Kumar Bishwas, does not stand the test of whether it's an instrumentality or not, Your Lordship. With that, Your Lordships, the council would like to expand on the fact that the consent provided under this particular privacy policy page must be free, informed, and explicit, Your Lordships. In this instant case, under subsection 2 of the DPDP Act, consent for data processing must meet the following criteria, Your Lordship. Under that, the consent must be free and voluntary, that it must be specific and explicit. In this instant case, the consent, although is free and voluntary, it does not satisfy whether that is specific and is explicit or not, Your Lordships. Since there is no, since the provision as to whether the consent is specific, there is no specificity with regard to the storage of bank details, and explicit consent with respect to assigning the data transfer or the data handling and processing of another third party is not enshrined in the Act, Your Lordships. If Your Lordships are satisfied and there are no questions, the council would like to move the play.
Yeah.
Just one more question.
Indeed, Your Lordship.
Can you prove or establish very clearly that the storing bank details for recovering payments
Indeed.
is not only unnecessary, but also fails the taste of least intrusive means?
Pardon, Your Lordship.
It fails the taste of how it fails the taste of least intrusive means.
Least intrusive means, Your Lordship.
Intrusive, INTRE.
Indeed, indeed.
Intrusive
Your Lordship,
means.
in the instant case, the particular storage of bank detail is in fact intrusive and therefore antithetical to the test, to the fact that the particular storage was not consented to in the privacy policy page. The particular payment data clause which is there in the appendix only pertains to collection of data and not the retention of data. Therefore, it is antithetical to the test of whether it is intrusive or not. Obliged. Lordships, the council would like to move with the prayer.
Yeah.
So, Lordships, therefore, in light of the issues raised, arguments advanced, and the authorities cited, it is humbly prayed before the Honorable Supreme Court of India now that it be pleased to declare and adjudge that the instant writ petition be allowed, that Section 6 and other allied provisions of the Act be declared unconstitutional on account of violation of Article 21, that the processing of bank account details does not constitute a legitimate purpose under Section 7 and the other allied provisions of the Act, that Section 35 of the Act violates the petitioner's right to seek remedy, that the exemption of certain data fiduciaries under Section 17, subsection 5 is to be declared unconstitutional and violative of Article 14, and any other order that the court may be deemed fit to pass. It was an honor arguing for.
Arguments of respondents. Yeah. Who is the first speaker? Respondent.
How much time is left?
4 minutes left.
The council seeks permission to submit the compendium of cases. Apologies, Your Honors, there has been only one compendium because of exigencies, but we'll refer and cite what is there in the compendium for your benefit. Greetings to the Honorable Court. The Council seeks permission to address the benches, Your Honors. Much obliged, Your Honors. Your Honors, this is Council number 35, with this co-counsel, and we are representing the side of the respondents in the case of Mr. Aman and others versus the Union of India. Your Honors, out of the allocated 45 minutes, I shall be speaking for 22 minutes. Your Honors, I will be addressing issues 1 and 2. Your Honors, before we move on to the submissions, are Your Honors well versed with the facts of the case?
Yeah.
Much obliged, Your Honors. Your Honors, before I begin with the issues, I would like to draw your attention foremost to the long title of the DPDP Act, Your Honors. It talks about, if the Council may read, an act to provide for the processing of digital personal data in a manner that recognizes both the right to individuals to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith or incidental thereto. Your Honors, the words lawful purposes and connected therewith are highly essential. Now, may I direct Your Honors' attention to Section 4 of the Act, Your Honors. Your Honors, it reads, a person may process the personal data of a data principal only in accordance with the provisions of the Act and for a lawful purpose in two forms, Your Honors. Two, for which the data principal has given her consent or for certain legitimate uses. Your Honors, certain legitimate uses as per Section 2D of the Act have been defined that all uses specified under Section 7 of the Act, Your Honors. So this is a very important distinction which the Act in itself is creating, Your Honors. Because everywhere in the Act, there is a requirement of consent, as is very well established by this Honorable Court in the case of K.S. Puttaswamy versus the Union of India. Since right to privacy is an essential right under Article 21 of the Constitution, consent forms the cornerstone of ensuring that this is not infringed. However, Your Honors, Article 21 is not an absolute right. In the case of Maneka Gandhi versus Union of India, it was held that such a right can be infringed upon by express statutory provisions if they are just, fair and reasonable. And also, Your Honors, in Gobind versus State of Madhya Pradesh, which was the first case that opened the discussion on right to privacy being included under Article 21, it was held again that it is not an absolute right, and also observe that it can be curtailed by a provision of law if there are two grounds which are met. One, they are narrowly tailored, and second, there are compelling state interests which are involved in curtailing such a right. Your Honors, by applying the authorities cited by the Council and the Acts, it is stated in the first issue, which talks about whether Section 6 and its allied provisions are violative of Article 21, Your Honors. In this, Your Honors, Section 6.1, as rightly mentioned by the Council for Petitioners also, talks about free, fair, and informed consent, Your Honors. And across the section, it is always supporting the fact that there must be consent whenever there is whenever information must be acquired or obtained by any data fiduciary. And Your Honors, Section 6, subsection 6, which was mentioned by the Council for Petitioners, it must be noted, Your Honors, that it talks about withdrawal of consent. So when Your Honors asked that was there an opt-out clause, Your Honors, it is given in the language of the Act itself that this consent is not a one-time provision. If the data principal at any point of time chooses to withdraw her consent, that can be done, so Your Honors, which is why an explicit permission on behalf of medicine company was not required to be given the data permissions page. It is mandated by the statute itself. Your Honors, in the first, the consent part, the Council is submitting that by giving the data permissions page to the data principals, before they take the subscription-based model for engaging in subsidies and benefits for health insurance and pharmaceuticals, a consent was taken as is mandated by the Act. While the issue of bank accounts is different, the Council will just come to that in a moment, Your Honors. Your Honors, when consent is taken, the notice highlights what payment data has to be taken, to what extent it will be taken. And Your Honors, if the Council may bring your attention to the first opening paragraph of the permissions page, it says it includes, but is not limited to the following, Your Honors. Now, Honors, this is an important provision because when consent is taken, the medicine company has explicitly mentioned to what extent this consent will be used, which is again part of the specified objective.
Isn't that ambiguous, leaving room to unguided discretion?
Yes, Your Honors. It is indeed, Your Honors. It may come up as ambiguous. However, Your Honors, it must be noted that because it is a government entity, and this page must be read with the exact details which are highlighted out from point 1 to point 8, Your Honors. That is the distinction that the council is submitting. That if this page ended at the word payment data and it would not have specified to what purposes will it be used, then your council would have agreed with Your Honors that it is discretionary. However, when there are 8 points, which also include the aspect of third party, which talk about targeted advertisements, it also talks about the purpose of fulfilling and managing their orders in point 4. Your Honors, these are the purposes, which means that if the data was taken beyond these purposes, and it had no reasonable nexus with this, then such an ambiguity or discretion would have stood, Your Honor. However, when there are 8 points which highlight the same, this is not a discretionary power. It only states that to fulfill in furtherance of this, the information can be taken. That is a very important point that the council is submitting on us.
The counsel for the petitioner argued that the proportionality is not mentioned.
Yes, sir.
So in the light of the Puttaswamy judgment, how do you argue that the act balances the individual privacy with a legitimate state interest?
Much obliged, Your Honors. Your Honors, to reiterate the 4 grounds of proportionality from Anuradha Bhasin versus of Union of India, and the council will then apply the facts to prove how it is substantiated. The first prong states, as also mentioned in paragraph 14 of the memorial, it states that the law encroaching upon the privacy must pursue a legitimate objective. Your Honors, in the long title, it is clearly stated that it has to be for balancing the interest of the private individual for protecting their data, but it is also to obtain data for all lawful purposes, which is why, Your Honors, the council had shown you section 4, which talks about 2 ways of obtaining data, through consent and through lawful purposes. And therefore, Your Honors, the first prong is satisfied. Second, Your Honors, it says that there must be a rational nexus between the law and the objective. Your Honors, throughout the course of the act, be it the rights of the data principal, the duties of the data fiduciary, which is the state and the medicine company in this case, Your Honor, along with section 6, section 5, all of them highlight how consent is essential before taking a data. That means the first part, which is the right of the individual, is being protected through all of these sections, which is balancing the private interest. And when there is the second aspect of protecting the community interest, there are certain exemptions, Your Honors, which are must in any legislation, Your Honors. Because if we look at various legislations which have been enacted across...
Where are the safeguards? Exemption is necessary, that is fine.
Yes,
where are the safeguards?
Your Honors, this act, it must be noted, was passed in January, and all of this has taken the course of 1 year, Your Honors. And Your Honors, it is legislative practice that if an act has been passed, at times it is not possible to pass the rules with it. Therefore, by reading the act itself, for now, for the time being, this act is the sole policy and also the sole law which deals with the issues, which is why the council is, for the respondents, is submitting that all interpretation must be limited to the DPDP Act, Your Honors, and it must not indulge in any other reference, because there is no policy which has been enacted yet. And Your Honors, it may you may ask that by when will the rules come, or why do we not have a policy? But Your Honors, as counsel for respondents, it must also be pointed out that the role of judiciary, with all due respect to Your Honors, is to adjudge the present law of the state. Although the judiciary may direct the respondents to pass a certain rule or a certain guidelines. However, in this present case, Your Honor, because the jurisdiction has happened within the scope of the act and there are no rules, the interpretation must suffice and must be limited to the act itself, Your Honor.
Now here, your memorials, they say that there is deemed consent. What is called a deemed consent?
Yes, Your Honors. Your Honors, deemed consent means that in the factual matrix, Your Honors, it must be focused on the first word that provides in first paragraph, it talks about subsidy-based recurring system model, which means, Your Honors, recurring means on a month-to-month basis. Every time there is a transaction regarding the orders, pharmaceuticals, or insurance, the payment date by initial processing by safety GPT. Your Honors, the word initial processing by safety GPT is highly important because it has the first contact with the data. Your honors, even though it is not highlighted in the proposition, the bare understanding of the word processor, as per its definition, states that it is specifically hired to first collect the data, process it, streamline it, and then store it in the servers of the data fiduciary, your honors. And your honors, the petitioners had argued that it should have only processed the data and not stored it. However, section 2X of the act, your honor, it defines that processing means also storage. Your honors, the council shall read the provision. It says, such as collection, recording, organization, structuring, storage, adaptation, retrieval, alignment, combining, etc. Your honors. Which means the word processing has been given broad guidelines with the objective of pursuing that it cannot only stop at processing, your honors, because data is in a digital format. You cannot have separate entities at every stage doing separate functions only in the purpose of safety. It is not efficient nor practical, your honor. Yes, your honors. Much obliged. Your honors, if you're satisfied with, and your honors, just to cite a few case laws which convinces your honors that this act is where interpretation must lie. Your honors, in the recent case of Vivek Narayan Sharma versus Union of India, which was a demonetization case, the judiciary held that the courts should exercise judicial restraint and not enforce their own preferences or interpretation of law on the wisdom of legislature's policy, honors. So, your honors, the GDPR, which has been cited multiple times by the petitioners, even though it has persuasive value in the act, your honors, but it must be noted that this act has been passed in Union of Indiana. Union of Indiana is a separate entity than the European Union. There are different exigencies, there are different requirements of the people that the state must attend to, your honors, which is why, and your honors, interestingly, GDPR itself also has a certain safeguard and exemption clause, which states that national security and protection of sovereign interests can be used to protect and to obtain data from the individuals without the consent, your honors, which is why GDPR.
But you're citing that because there is a lack of guidelines issued by the government.
Your honors, the council is not citing that to prove the council's point. The council is stating the act is the DPDP Act is what must be followed. However,
understood.
Yes,
but
your honors.
there is no reference.
Yes, your honors.
For the government to follow. There is lack of guidelines. So that is why there has to be some guidelines to be followed. That's what they're referring to GDPR.
Much obliged, your honors. Indeed, your honors. However, your honors, it must be brought to your honors' attention that the B.N. Krishna Committee report was first established by the Union of India in 2017 to discuss the very same provisions, your honors. And in that committee report, it has cited various prongs of GDPR, various recitals. However, because it has considered the Union of Indiana into its aspect, it has also differed from GDPR in certain aspects, your honors. Which is why the B.N. Krishna Committee report must be one of the first sources which should have persuasive value before the bench, your honor. That is also an important point. Your honors, if you are satisfied with the first issue and you have no further questions, your honors, proceed to the second issue.
Point two. Yeah.
Much obliged, your honors. Your honors, the second issue talks about whether the bank account details constitute a legitimate purpose under Section 7 of the Act. Your honors, to draw your attention to the language of Section 7 and also its title, it talks about certain legitimate uses, which means, your honors, as also proven from Section 4 of the Act, consent is not required under Section 7, your honors. So consent of Section 6 is not to be read with Section 7. Consent must be read as per Section 7, subclause A, and Section 7, subclause B, under Section 7 itself, your honors. This is an important distinction of understanding what consent is. If Section 6 talks about free, fair, informed, unambiguous, specific consent, Section 7 has certain fetters on it because legitimate purposes are pursuing compelling state interests and interests of the data fiduciaries. Your honors.
Do you have any precedent to cite this line of argument? You're telling that it should be argued in that manner. So do you have any precedent? Not in terms of this particular act, but as a general principles of interpretation.
Your honor, the general principle, like although there is no case law authority which the council is aware of at this point, but through interpretation, it must be read that it should follow a strict interpretation in the sense, your honors, that if the Section 4, 1 and 2 has a distinction of or means that there must be different approaches, your honor. And your honors, it also must be noted, Section 7 says a data fiduciary may process personal data, your honor. And Your Honor, this is not an instance that the respondents are representing the state stating may cannot be read as shall, Your Honor. The counsel on the respondents is assuring Your Honors that this practice of pursuing legitimate objectives and taking the data of individuals without their consent is not a regular practice, Your Honors. If it were a regular practice, there would not be throngs of provisions under the Act itself which talk about consent and prove its sanctity, Your Honors.
Can the government escape liability by that it is may, and can it hamper the public interest?
A clarification, Your Honors. Are you questioning this regarding a general application or in the present factual matrix, Your Honor?
You are referring to the may part of section
Yes,
7
Your Honor.
clause 8.
Yes, Your Honor.
So your argument is trying to, establish that, the government may not do that, but in that, as a consequence, can it have a negative consequence on the public interest?
No, Your Honors, it will not. The council is agreeing with you that this cannot be a broad ground. However, Your Honors, the courts, the Honorable High Courts and Supreme Court of Indiana have also in various precedents stated that when there is a certain lack of interpretation, especially in like may clauses, then the words which have been cited by my learned counsels on the petitioner side, such as national security, protection of state interest, sovereignty, they must be interpreted on a case-to-case basis, Your Honors. So when the first counsel comes and stated that the facts are not important because constitutionality is being challenged, but Your Honors, we are before this honorable bench because the facts are important, Your Honor. Your Honors, if we look at the facts, in the first prong of the submission, the council will satisfy that section 7A has been satisfied. Your Honors, section 7 subclause A says, for the specified purpose for which data principal has voluntarily provided her personal data to the data fiduciary and in respect for which consent has not been indicated. Your Honors, the specified purpose has been mentioned in appendix 2, the data permissions page, very clearly, Your Honors. And it has also stated that the consent should be voluntary. Your Honors, if you look at the facts and appreciate them, it is a membership-based model, Your Honors, which means only the members who have voluntarily agreed to be a part of the subsidy scheme of medicine company are the entities who have given their voluntary consent, and thus they are brought under section 7A of the Act, Your Honors. And Your Honors, section 7B, Your Honors, just to clarify, the council is not submitting 7 trying to justify that in various parts of section 7 also, these facts are being satisfied, Your Honor. Section 7B talks about for the state and any of its instrumentalities, and as rightly proven, medicine company is an instrumentality of the state, Your Honor. It states that to take any subsidy, benefit, service, license, or permit, this must be satisfied. So therefore, Your Honor, it says she has 7B subclause 1. It says she has previously consented to the processing of her personal data by the state. And then it again reiterates by subsidy, benefit, service. Your Honor, the proposition and the facts itself clearly state that medicine company is giving a subsidized based model to its members. Therefore, to be classified as a subsidy, there has been consent also, Your Honors. Therefore, if consent is there and it is also a subsidy as mentioned in the factual matrix, Your Honors, then 7B is also satisfied. And Your Honors, as we've also discussed, when there are this provision is there, subject to standards followed for processing being in accordance with policy issued by the central government. Your Honors, they cited in Re Delhi's Act. However, this was the first case law which dealt with the understanding of delegated legislation. However, in the book of Professor I.P. Massey, there are multiple cases which discuss what delegated legislation means, and there is still no final position of law except on 2 grounds, Your Honors. The first,
can you cite any contradictory judgment?
Your Honors, the council is not able to remember, Your Honors. However, if it comes to light, the council will mention. However, Your Honors, the 2 prongs which must be satisfied are, if there must be a parent enabling act which vests the power in the delegate, and that delegate must not pass any law which goes beyond the policy of the act, Your Honor. Your Honor, in this, the enabling parent act is the DPDP Act, Your Honor, and the power of the central government to decide the course of policy, to decide where the exemptions follow, what procedural safeguards must be issued, are in accordance with such delegated legislation, Your Honors. Therefore, their argument is void, and this submission must stand, Your Honors, that this is a valid delegation. Your Honors, on this basis, the council submits that bank account details as per the facts were, and Your Honors, since you talked about the case of less intrusive means, Your Honors, this doctrine is a very valid document, and even in illustration of section 6.1, there is a very detailed case which highlights why this doctrine must be upheld. However, Your Honors, it must also be noted and must be appreciated that there is also a doctrine of necessity, and in the permissions page, the payment data says we must collect all data which is necessary, such as the payment security code, and it also uses the word etc. Now, Your Honors, it may come off as wide to you. However, it must be noted that this payment system, as the council has also rightly pointed out, it was a recurring basis. So for a recurring basis to work out, the state, in all practicality, and the data fiduciary, at every instance that there are lakhs of members who are being part of the service because it is a government entity, Honors, it cannot at every instance process such data, take the consent, again process the payment details, and keep on doing it on a recurring basis, Your Honors, because there are different aspects and different functions that the medicine company must also be ensured, which is exactly why Safety GPT was hired, Your Honors. And Your Honors, to assure you, the council accepts that even though there was a breach, there was a certain negligence that will be investigated, Your Honor. It has already, as per the facts, has had a preliminary investigation, and the council in no way is escaping liability on the grounds that Safety GPT is the only entity which should be liable. However, since it is an Article 32 petition, the council is submitting that in this fact, as per this facts, these particular subsections and sections of the act must not be struck down and they must be upheld, Your Honor. That is the final submission that the council is making. It was a pleasure arguing with you. Are there any other questions, Your Honors? No. Much honor. Speaker 2.
May I start, Your Honor?
Yes.
The council wishes Your Honors a very pleasant afternoon. Your Honors, I'll be addressing the court for next 20 minutes regarding the issue 3 and issue 4. Issue 3 is regarding the immunity granted to the state under section 35, and issue 4 is regarding the exemption of certain data fiduciaries through a means of notification under section 17 subclause 5. Before moving to the issues, Your Honor, the question posed to my co-counsel regarding the case laws for the policy guidelines, Your Honor, I would like to cite the case law from the US jurisdiction, that is of Poultry Firm versus Compter. Your Honor, in the US also there was the law first that only whatever written in the statute must be followed. However, throughout specifically in this case, am I audible, Your Honors? Specifically in this case, it was first upheld that the policy of the law must be also taken into the consideration, Your Honor. Your Honor, if that query is satisfied, I may move on to my submissions, Your Honor. Your Honor, beginning with the issue 3, the council most humbly submits that the immunity granted to the state is valid and constitutional, as it only restricts the right to the people to sue the government when it acts in good faith in accordance with the law. Your Honor, the present argument is twofold. Firstly, that the immunity granted to the state is constitutional and valid. Secondly, good faith provides a legitimate defense against the grant of remedy. Proceeding with the first limb of my submission, the doctrine of sovereign immunity originates from the maxim rex non potest peccare, which means that the king can do no wrong. Your Honor, the council knows that this doctrine is an antiquated common law principle, and our constitution, Article 300 subclause 1, limits the application. And to uphold this application, the limited application of this particular doctrine, Your Honor, in the particular statute of DPDP, section 35, if I may read it verbatim, Your Honors. Your Honor, the title of the section particularly reads as the protection of action taken in the good faith. The section reads as, no suit, prosecution, or other legal proceedings shall lie against the central government, the board, its chairperson, and any members, officer, or employee thereof for anything which is done or intended to be done in good faith under the provisions of this act or the rules made therein under. Thus, Your Honor, this doctrine of sovereign immunity is limited in this act through good faith. Your Honor, the doctrine of sovereign immunity, as held in the case of Kasturi Lal Rala Ram Jain versus State of Uttar Pradesh, the agents and representatives of the government can be protected from the liability for discharging their duties that are governed by the purview of the statutory obligations that they are acting under. Further, Your Honor, good faith, as defined in Section 3, Subclause 2 of the General Clauses Act 1897, defines it as good faith entails actions done honestly, regardless of the negligence. Good faith clauses limits the ability to seek the remedies to the situation beyond the statutory functionaries' honest actions, Your Honor. The doctrine supports sovereign immunity by presuming bona fide intent in the governmental actions unless proven malified intention, Your Honor. Your Honor, the onus is on the petitioners to prove that there was a malicious intent on the part of the government. Your Honor, the case of State of Gujarat versus Paresh Nathalal Chauhan, it was held as provided in the footnote number 71 of the memorial submitted, Your Honors. Your Honor, in this case, Your Honor, the memorial submitted.
Okay.
Yes, Your Honor. Your Honor, as in the case, it was held that the bar against seeking of the remedy is limited to the nature and the scope of the good faith clause inserted in the statute. Now, the good faith in the present instance can be shown through proposition page number 2, last paragraph, where it states that as soon as the medicine co got the information regarding that there might be some data breach, they asked the safety GPT, the third party, to erase all the data. Your Honor, this is in accordance with the Section 8, Subclause 7 of the Act. If I may read it verbatim, Your Honors. Your Honor, Section 8, Subclause 7 states that a data fiduciary shall, unless retention is necessary for compliance with any law for the time being in the force, A, erase personal data upon the data principal with withdrawing her consent, or as soon as it is reasonable to assume that the specified purpose is no longer being served, whichever is earlier, and cause its data processor to erase any personal data that was made available by the data fiduciary for processing to such data processor. Your Honors, Medicine Co. has asked the data processor here, the safety GPT, to erase the data which was there with them of the 4,500 customers, Your Honors. Your Honors, in the present case, Medicine Co. is a government entity which is also controlled by the government, and it operates to provide subsidized medicines for the public welfare and also provides subsidized insurance services. Your Honor, this is a function integral to the state sovereign's obligation and socio-economic responsibilities. Your Honor, Section 35 of the Act shields the state from the liability from such actions. The provision establishes specific avenues for data principals to address grievances related to the data misuse, ensuring adequate remedies within the statutory framework. Your Honors, as held in the case of Union of India versus T.R. Verma, as also provided in the footnote number 64 of the memorial submitted, that the when a state exercises a statutory obligation, an injury within the scope of the statute must be remedied through effective legal alternative remedies which are available to the litigant from the statute itself. In the statute itself, if I may point out the alternative remedies which are given, Your Honors, it is Section 13, which is the grievance redressal by data fiduciaries, Section 27, which is inquiry by data protection board, Section 29, which is an appellate tribunal formation and the inquiry by the appeals. If the petitioners are not satisfied with what has been ordered by the data protection board, they can go to the appellate tribunal, Your Honor, which has not been done in this present case. They have come directly to the courts, Your Honors, and this coming to the courts at this stage is unwarranted, Your Honors.
Counsel, I get your point regarding the importance of good faith. If you refer to the fact sheet, you will see that a lot of consumers, users, citizens have come to the brink of bankruptcy, right? And we consider this country to be a welfare state, right? So considering that, the question is, how do you justify this inclusion of good faith immunity when the scale of breach and the delay in disclosure indicate potential gross negligence? And the follow-up question, could this immunity potentially set a precedent for circumventing public accountability? How does the state propose to limit its abuse or misuse?
Your Honor, here the negligence was done on the part of Safety GPT and not on the part of the Medicine Co. Safety GPT
Does
is a
that
third
reduce
party.
the liability of Medicine Co?
No, Your Honor, that would not reduce the liability of the Medicine Co because Medicine Co has taken sufficient steps. They have asked for the erasure of data. They have even conducted a preliminary investigation. Your Honor, at this stage, appropriate information with them itself is not there because only preliminary investigation is done. Your Honor, as per the proposition page number 4, it has cited that the petitioners stormed into the offices of Medicine Co. Your Honor, the investigation was still under the process. If the investigation would have been continued, we might have some more information as to how the data was leaked and how the negligence was there on the part of Safety GPT, Your Honors.
The law only talks about post-infringement measures. Is there any preventive measures that have been mandated by the Act, and what specific technical or contractual safeguards were in place to ensure that third-party vendors complied with the law?
Yes, Your Honor. Indeed, Your Honor.
Speaker, one more question is there. What is called as sovereign function?
Yes, Your Honor. Your Honor, sovereign functions.
And how, in the context of your argument, how a medicine company can be said to perform sovereign functions or sovereign duty?
Yes, sir.
We got case law of BWSSP versus Rajappa of the Supreme Court of India that demarcates what is sovereign, what is not, what is non-sovereign.
Indeed, Your Honor.
In the context of the work which the medicine company performs, how you say that it is performing a sovereign duty? See, judges, they perform sovereign functions, isn't it? Whether officer of a department of transport, he performs a sovereign duty? No. How? So the same work of a medicine company, somebody else also can do it. How you equate that this particular medicine company is performing a sovereign duty or sovereign function and that they are exempted?
Indeed, Your Honor. Answering to your question, Your Honor. Your Honor, if I mention a book by distinguished Professor I.P. Messi, he says that how the government has transformed from a laissez-faire system to a materialistic form of government. Your Honor, the government is giving several functions. It is performing several functions, giving several other services to the people of the country, Your Honor. It is a democratic form of the government. It is giving services. If I mention the appendix 2 of the, proposition, Your Honor, appendix 1, apologies, Your Honor.
Yeah.
Your Honor, appendix 1 specifically exempts Indian Railways, Caterings and Tourism, Jeevan Insurance Company, Indiana Gas Limited, Indiana Thermal Power, Samveta Medicine Co., Reserve Bank of India, Indiana Electronics Limited, Indiana Testing Agency, Indiana Aeronautics Limited. Your Honor, this is very limited. Here, all the sovereign functions has been conducted as they are performed in the welfare of the people, Your Honor. Your Honor, even though they might have commercial models like IRCTC, the Indian Railways Catering and Tourism Corporation, it is a government-owned entity and it has a commercial model. However, as it performs the public welfare function, it would come under the sovereign functions, Your Honors.
My question is this.
Yes, Your Honor.
What we are looking at is the constitutionality of Section 35. Right? Any other provisions or any other act has a similar provision, or this is unique for DPDP?
Your Honor, there are other acts where there are other provisions. For example, Section 157 of the GST Act, Section in UAPA Act, also there is a section for, I think, Your Honor, Section 49, if I may just verify it from the memorial, Your Honor.
49, yeah.
Yeah, Section 49, Your Honors. Your Honor, in Competition Act also, there has been a provision, which is Section 59. In Drugs and Cosmetics Acts also, there is a provision for good faith immunity for the state, that is Section 37, Your Honors. Your Honors, if there are any other questions?
If you can
Yes,
highlight
Your
on the
Yes, Your
safeguard,
Honor. Indeed, Your Honor.
technical safeguard that has been taken. I mean, can you establish that safeguarding constitutional rights have been given more priority than commercial gain?
Indeed, Your Honor. Your Honor, the Act itself came for the protection of the data of the citizens, Your Honor. The protection of the data of the citizens comes under the right to privacy, which is regarded as a fundamental right in the case of the K.S. Puttaswamy versus Union of India, Your Honor. So, Your Honor, the Act itself is a testament of protecting the rights of the citizen, Your Honor. And when the exemptions and the immunity is provided to the citizens, Your Honor, it is also to the state, Your Honor. It is also for the benefit of the citizens, Your Honors. Your Honors, Article 21 of the Constitution also has right to health. So when they are exempting entities like Medicine Co, they're providing subsidized medicine services, which promotes right to health of the people, Your Honors. Your Honors.
Is there any interpretation to say that subsidized service is a part of right to health?
Subsidized-
Is there a precedent which say that providing subsidized medical service is inclusive of right to health under Article 21?
Your Honor, the council is not aware of any precedent as such. However, Your Honor, if you perform a interpretation of what right to health could come under this, and also if you look at the DPSPs, the directive principle of the state policy, which are there specifically, if I may point out, Your Honor, Article 47 and
Non-enforceable in this court.
yes, Your Honor, DPSP is not enforceable in the court. However, Your Honor, it is a duty of the state. As the state is materialistic and a democratic form of the government, it is the duty of the state to do in as much as their power is to perform and to fulfill these DPSPs, Your Honors. Your Honor, if I may move to the fourth issue.
Yeah.
Proceeding to the fourth issue, the council submits that the exemption of certain data fiduciaries under section 17 subclause 5 by means of the notification does not violate Article 14 of the Constitution of Indiana. The present argument is twofold. Firstly, the notification qualifies the twin test of reasonable classification. Secondly, the notification does not represent an arbitrary exercise of the governmental discretion. Proceeding to the first limb of my submission, the council most humbly submits that the notification qualifies the twin test of the reasonable classification necessary to uphold Article 14 of the Constitution of Indiana. Your Honors, Article 14 of the Constitution mandates equality before law and equal protection of the law. Your Honor, over the course of the judgment, specifically starting from State of West Bengal versus Anwar Ali Sarkar, the courts has held two grounds for the reasonable classification. Firstly, the intelligible differentia, and secondly, the rational nexus. Intelligible differentia means that the classification must be based on rational distinction and that are clearly identifiable and relevant to the object of the legislation. Rational nexus means that there must be a logical connection between the classification and the object sought to be achieved. Your Honor, in the present case, the exemption under section 17 subclause 5 forms a classification grounded in intelligible differentia. This is because in the present case, Your Honor, government entities like Medicine Co providing essential public welfare services, as already pointed out by the council, that they are providing public welfare services such as subsidized healthcare from forms of well-defined class, Your Honors. This class is distinct due to its heavy regulations and oversight by multiple ministries, as also mentioned in the proposition para number 1, Your Honor, that this entity has been regulated by Ministry of Corporate Affairs and Ministry of Information and Technology. Unlike private entities, the government entities which has been exempted face an additional layer of accountability and are subject to stringent public interest mandates. Along with that, Your Honor, the classification also aligns with the legislative object of balancing data privacy with the public interest. While the Act's primary aim is to ensure that the data privacy is maintained, it also acknowledges that the legitimate need for flexibility in sectors like healthcare and thermal and aeronautic sectors that have been mentioned, Your Honor. Your Honor, also this exemption, if I may read through the section 75 subclause 5 of the Act, is for specifically next 5 years. It is for the phased implementation. Your Honor, the Act has come recently in 2023, and these entities are really important for the country. Your Honor, to them, for functioning smoothly, we need the exemption for the next 5 years, that is till 2027, Your Honors. Your Honors?
Since you're, sorry for the
Yes.
interruption. Based on your, since you're representing the government as a respondent, the specific question is on what grounds the entities which are mentioned, especially like Medicine and Company, they were chosen for exemption. And can you demonstrate that this exemption was based on objective criteria and not arbitrary decision making?
Yes, Your Honor. Your Honor, the reasonable classification that has been done is because that they are providing subsidized health services, Your Honor. This is, as already mentioned, it is for the public welfare services, Your Honor. They're not arbitrary because these are all well-defined class as they perform the sovereign function, Your Honors. They are for the socio-economic benefit, Your Honors, and they are not for any other thing, Your Honor. It is everything what is the democratic government is doing is for the welfare of the people, Your Honors.
The present test of arbitrariness is whether there is proper guidelines or,
Yes, Your
there
Honor.
is
That is the second.
discretion is guided or not. We see there is a lack of, proper guidelines or, pointers to be followed here. So can we assume there is arbitrariness because there is unguided discretion on the part of the government?
Your Honor, that is exactly the second limb of my submission, that how it is not arbitrary, Your Honor. Your Honor, I invite your attention to page number 34 to 39, flag number 9 of the compendium submitted, Your Honors. Your Honor, the compendium submitted is flagged.
This one? Red one. Yeah. Which case, ma'am?
If the council is with Your Honors.
Yeah.
Which
Your
page
Honors, in
number?
this page number 34 to 39, specifically flag number 9.
Yeah.
Your Honor, this is for the case Shaira Bano versus Union of
Yeah.
India. Your Honor, in this case, the test for manifest arbitrariness was there, that it held that any unreasonable, capricious, or lacking a clear guiding principle, any law which does so, was deemed unconstitutional. Your Honors, the standard for applying the test of manifest arbitrariness is reflected in the word manifest, which means visible and palpable, as held in the case of the demonetization judgment, the Vivek Narayan judgment. Your Honor, a statute is not considered arbitrary if it contains guidelines that can be inferred from its preamble, long title, and other provisions, as held in the case of Chandrakanta Shaha versus Union of India, also provided in the flag number 2 of the compendium submitted. The relevant portions have been highlighted, Your Honors. Your Honors, even with a significant discretionary authority is granted to the government without explicit safeguards or guidelines, such power has been upheld as valid based on the expectation that the government will exercise them with great caution and responsibility, as held in the case of Lakshmi Khansari versus Uttar Pradesh, flag number 6 of the compendium submitted, Your Honor. So, Your Honors, in the present case, the Act's preamble and long title provide sufficient guidelines to ensure that the discretion under Section 17, subclause 5 is not arbitrary. The provisions emphasize balancing data with public welfare and regulating the data processing. The exemption aligns with the statute purpose and is consistent with the policy framework, Your Honors. The exemption granted under Section 17, subclause 5 is subject to oversight and regulation by multiple ministries and government bodies, as mentioned in the para 1. And also, Your Honor, this ensures that the exercising of discretion is reasonable and careful. Here, the exemption supports operational flexibility without compromising the data privacy goals. Hence, Your Honor, therefore, the Council submits that the exemption of certain data fiduciaries under Section 17, subclause 5 may seek an extension for 30 seconds, Your Honor.
Okay.
By means of notification does not violate Article 14 of the Constitution. Your Honor, are there any questions?
Last question.
Yes, Your Honor.
Given this data breach and public backlash, do you believe that the immunity clauses erodes the government's credibility in enforcing its own privacy laws? Should the entities which are handling sensitive data, they should undergo external audits, right? Can the law mandate that there should be external audits?
Your Honor, they are already going through multiple ministries, as already mentioned in the para. That's how that Medicine Co is going through the audits in through Ministry of Information and Technology and through Ministry of Corporate Affairs. Similarly, Your Honor, the other entities which I mentioned would also be going through external audits, Your Honor. That is already given, Your Honor, that they will be going through the external audits, and the government will not take any other action which will not be against the welfare of the citizens here. Your Honor, if I may proceed to the prayer submitted.
Yeah.
Wherefore, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed before this Honorable Supreme Court that it may be pleased to, first, declare the provisions which grants the power to process personal data without taking consent under Section 7 are justified for the public welfare and hence constitutional. Second, declare that the processing of bank details by Medicine Co was a legitimate purpose under Section 7 of the Act. Third, declare that Section 35 of the Act does not take away the right to seek remedy for the petitioners and an individual, since it grants specific and qualified immunity for the act done in good faith. Fourth, declare that the notification allowing the exemption of certain data fiduciaries is necessary for administrative functions and justified under the law, and pass any other order it may deem fit in the ends of equity, justice, and good conscience. It was a pleasure arguing before this court, Your Honor.
Thank you.
Keep it brief.
Council seeks permission to begin the rebuttal. If Your Lordships, am I audible?
Yeah.
Lordship, the council would like to pay 6-point rebuttal. Hello. The council would like to pay 6-point rebuttal to the arguments placed by the council, Your Lordships. Firstly, with regards to the issue of safeguards, council number 1 had established that since there is no rules in place for with regards to DPDP Act, and therefore the safeguards cannot be decided by this honorable court. Lordships, the law needs to be decided as on this particular date, Your Lordships. As on this particular date, since the DPDP Act does not have any safeguard, the provisions as mentioned by the council ought to be struck down, Your Lordships. Secondly, with regards to the question of opting out, Your Lordship, the council 1 had referred to section 6 clause 6, whereby the procedure for withdrawal has been given. Lordships, even though procedure for withdrawal has been given, Your Lordship, the information can be retained by the state and its instrumentalities indefinitely, even though the right to be forgotten is only given against a non-state entity. Under section 17 clause 4, the right to be forgotten is not against the state entity, and therefore it is arbitrary in nature, Your Lordships. Lordship, with regards to the reference to GDPR, the council referred to GDPR only for the tests that have been laid down and not for the provision. And the council had referred to Justice Sri Krishna committee to state that that ought to be the primary persuasive value before this honorable court. The council would like to state that Justice Sri Krishna committee also had provisions for data portability and the right to be forgotten, which has not been implemented by the DPDP Act 2022, Your Lordships. Lordships, with regards to section 2 clause 7, Your Lordship, the council had explained that processing includes both collecting and storing. But the council is trying to establish that processing under section 2 clause 2 does not refer to transferring of data to a third party entity, which has happened in the instant case, Your Lordships. Your Lordships, and the bad faith that the council is trying to establish and the negligence the council is trying to establish in the instant case is that without any contractual obligation, without any contractual provision, these data were transferred to a third-party organization, which is Safety GPT, which goes against the very purpose of the contract, and there is no consent ad in the instant case, Your Lordships. Lordships, Your Lordship, with regards to the arguments placed by the council number 2 as to what is a sovereign function and what is not a sovereign function, council stated example of IRCDC to state that there is a commercial element with regards to IRCDC, but it's humbly pleaded before this honorable court that no other private entity is allowed to do the function that IRCDC does. But in the instant case, Medico is an entity where other private entities are also allowed to provide medical services at a subsidized rate to the public. The council is able to remember at least one such organization, in Lordships, and therefore the same sovereign function cannot be attributable to medicine code in instant case. And finally, the council also mentioned that there are alternate remedies which could be undertaken by the petitioners, Your Lordships. Lordships, all the alternate remedies are classified as a proceedings, Your Lordships. And according to section 35 of the DPDP Act, any proceedings is being exempted from being challenged if the central government in good faith does it, Your Lordships. And for the same reason, even if it appears to be there is an alternative remedy, such remedy is not available at the hands of the petitioner. With this, the council would like to submit
whether this act has any rule-making power.
Indeed, Your Lordship. Section 40 of this particular act has the rule-making power, whereby central government has been.
So the issue here is there is no rules yet.
Lordships.
There is no rules yet.
There is no safeguards within the DPDP Act which protects the right to privacy.
Exactly, but there are rule-making power.
Indeed,
and we don't know how the rules are going to come up.
Indeed, Lordship.
What is the purpose of striking down the entire section before waiting for the
Indeed, Lordship. Lordships, even section 40 is an issue of debate, Your Lordships. Lordships, with regards to the DPDP Bill 2021, Your Lordships, the major criticism of the bill was that it gave extensive power to the central government to make rules. Lordship, the same provision has been replicated in the 2022 Act, Your Lordship, though it has not been challenged before this honorable court here. The council would like to make a passing comment that even section 40 is subject to constitutionality, Your Lordship. Therefore, with this, the council would like to submit this up. Much obliged.
Yes.
Much obliged, Your Honors. Your Honors, for the rebuttals, first and foremost, the council would like to bring your attention to the prayer that the petitioners have stated. They've talked about consent in all of their arguments, yet they have stated they want Section 6 and its allied provisions to be struck down, Your Honors, if you may refer to the petitioner's memorial. Your Honors, if such an important provision of consent is to be struck down, and the petitioners are arguing about reports which talk about consent, then why is Section 6, which is such a crucial aspect of data protection and privacy, being asked to struck down? That is the first rebuttal, Your Honors. Secondly, Your Honors, Section 40. First, the petitioners have highlighted how there are no procedural safeguards. They've referred to GDPR for tests which should be incorporated in the safeguards. They've also talked about delegated legislation, to what extent rulemaking should be delegated. And then when Section 40's question arose, they're stating that this was also part of major criticism because there are wide rulemaking powers. Your Honors, as a state, in general practice, even though this is a sensitive, the data is a sensitive aspect in today's world, Your Honors, the council accepts that. However, it must also be understood that a state, being the caretaker and ensuring welfare of all people, Your Honors, has to provide rules and needs the rulemaking power to ensure that there are safeguards for them. And Your Honors, if in the future, if there are any challenges to the rules, they can obviously be brought before any High Court or the Supreme Court, Your Honors. Nextly, talking about right to be forgotten. Your Honors, they're saying that nowhere that the state is not accepting this right to be forgotten. Your Honors, but in the facts, as proven by my co-counsel on page 2, last paragraph, the state agreed that the erasure of data, when it goes against the specified objective purpose for which it was taken, that must be erased. That means, Your Honor, there is a distinction. Here, the objective must be satisfied, which is also in line with the principles of data minimization and purpose limitation that the petitioners have cited. If the object is still being continued, then the data will be stored and processed. And Your Honors, Section 8, subclause 2, also grants the power to the data fiduciary to hire a data processor. So how can they say that a third party must be a part of contractual performance? The whole basis of data protection agreements, which are entered between a data fiduciary and a data processor, work on this principle and this legislation. Your Honor, in that way, you are hindering commerce. You are not allowing any such AI companies to come into existence because data fiduciaries do not have the option to hire a data processor, Your Honors. Therefore, all of these rebuttals, all of the concerns that the petitioners have today are merely apprehensive. They are not appreciating the constitutionality of the same, and they are also not respecting the legislative and objective of the legislative objective that the respondents are presenting before honorable.
It's also a fact that there are a lot of big number of citizens have been, have
4,000 cases.
yeah. So instead of doing measures which have happened after the breach, the government should strengthen its measure before this kind of data breach should happen.
Your Honor, since the time is up, just 30 seconds to answer your question, Your Honor. Your Honors, if we look at the facts are silent on what kind of due diligence was done by the medicine company, owners. But this act also does not say that it was done in bad faith. It does not say it was done carelessly, which means on interpretation, honor, if there is an agreement where they have highlighted the benefits that safety GPT brings to them, it can be reasonably presumed in good faith. And your honors, as you had asked my co-counsel, what is the importance of good faith? The similar question, it should be done after the breach. Your honors, good faith is an important presumption to avoid frivolous litigation. If you take away the presumption of good faith from the state, anytime any person just has an inkling that the state has wronged them and the state always has a bad intention, they can keep on challenging the state honors, and the state will never be able to undertake any functions for practical efficiency in the discharge's duty. Then the Supreme Court honor will also again ask the state, why you're not performing your duty. So honors, the state is trapped, and we just request you that you uphold the constitutionality, and if there are any losses to the petitioners in good faith, we shall reimburse to them.
So thank you. Where is your research assistants? Research assistants. They're there, but nobody opted for the help. Okay. So thank you very much. You did your duty well, both sides, and the facts are also challenging, and the act, the what you call the important elements of the acts, they're also quite challenging. Okay.
Thank you, teams. Thank you, judges. I now request the team ushers to escort the teams to the backstage while the judges score the teams.
Here only.
That's it.
Waiting.
The speaker is on.
Can you switch off?
Yes.
Great book.
Yes.
So this will proceed.
Thank you, judges. I now request the faculty in charge, Ms. Debasmita Ma'am, Assistant Professor, KLE Law College, to introduce the honorable judges.
A very pleasant afternoon to dear students, faculty members, our student volunteers, and esteemed judges. And a hearty congratulations to the participants for coming this far in the competition. It's my indeed honor to introduce to you our judges, Mr. Rajesh Velakat. Mr. Velakat is a highly respected partner at Fox Mandal, Bangalore office, where he plays a pivotal role in leading the firm's technology and startup team. In addition to his leadership in the tech sector, he also oversees the firm's corporate governance, capital markets, where his expertise is invaluable in helping the business navigate complex legal landscapes. Known for his deep knowledge and strategic insight, Rajesh has become the go-to lawyer for tech startups and innovators looking to scale their operations. Equally impressive with LLM from the London School of Economics and Political Science, MBL from National Law School of India University, BLLB from the University of Calicut. He is a member of several prestigious professional organizations, including the Bar Council of Karnataka. With his vast legal knowledge through leadership and unwavering commitment to his clients, Mr. Velakat stands out as one of the leading legal minds in the technology and startup space. I thank Sir for sharing his precious time with us this afternoon. I now invite Dr. Sunita B.H. to hand over a token of appreciation from our end to Sir. Our next judge, Mr. Vishwanath V. Angari. Honorable Mr. Vishwanath V. Angari is a highly accomplished and respected legal professional with a distinguished career in Karnataka State Judiciary. Sir holds a BCom degree showing a strong foundation in commerce and financial principles and completed a Master's of Law demonstrating his advanced expertise in legal studies. Sir has served pivotal roles showcasing his versatility and commitment to justice. Special Judge for Special Court to try multiple core fake stamp paper case in Bengaluru, Member Secretary of the Karnataka State Legal Service Authority, Director of the Bangalore Mediation Center, fostering the growth of alternative dispute resolution. Sir is known for his integrity, impartiality, and dedication to the law. His judicial tenure reflects a strong commitment to delivering justice, upholding ethical standards, and mentoring the next generation of legal professionals. Thank you, sir, for spending this afternoon with us in our learning process. Sunita, ma'am.
Thank you.
I now invite to you Dr. Abhishek Chakraborty. Sir is a distinguished academic and legal expert currently serving in the School of Law. He holds an LLB, LLM, and PhD, making him a highly qualified professional in the realm of law, with a particular focus on intellectual property law, biotechnology, and bioethics. Over the years, Sir has gained significant recognition from his scholarly contribution, particularly in the areas of patent law, copyright, and digital piracy. As an invited speaker, Dr. Chakraborty has shared his expertise on intellectual property rights across various prestigious institutions, including MNLU and the School of Business and Management in Christ. His contributions to academia also extend to guiding MPhil and PhD students, mentoring them in cutting-edge research topics like trade secret protections in software industry and patentability. Dr. Chakraborty's multifaceted contribution make him recognized as a leader in his field. His research, teaching, and active participation in global legal discussions underscore his commitment to shaping the future of law. Thank you, sir, for sharing your afternoon with us. Ma'am, kindly hand over the appreciation to sir. Thank you so much. I now hand over this podium to the court in charge.
Thank you, ma'am, for the introduction. I now request the judge ushers to escort the judges to Judge Lounge. Everybody rise.